Rosa, according to the facts provided, I consider you to have 3 claims of negligence for personal injury. I will discuss the relative strength of each claim, named against the Tate Gallery, the relevant church diocese and Mr. Khan, and advise you accordingly. In order to be successful in such a claim in negligence for personal injury, one has to prove that you were owed a duty of care, that there was a breach of that duty, that you suffered damage as a result, and that the damage suffered was not too remote per Donahue v Stevenson. First, I turn to the claim against the Tate Gallery, which I consider to be the strongest of the 3. Did the Tate Gallery owe you a duty of care? The 3-stage Capara test was developed to assess whether the duty was owed. Nevertheless, Wilson v English 1938 clearly demonstrates that an employer owes a contractual employee a duty of care, and therefore in relation to your first claim, the Capara test doesn't need to be satisfied. Next, one must assess whether the Tate Gallery breached the duty of care to you by answering 2 questions. Was the required standard of care given the circumstances, and whether the Tate Gallery fell below the required standard? In Blythe v Birmingham Waterworks 1856, Baron Alderson defined the standard of care and negligence and introduced a reasonable man. I anticipate the defence will launch their first counter-argument at this juncture. It could be argued that the medical knowledge of Artium is not filtered outside the medical community, and therefore the Tate were not aware of the risks. Examination into the Tate's operational methods will likely establish that they were aware of the risks, and therefore it's undisputable that Tate, as a reasonable employer, would expect their employees to handle solvents which are known to increase the likelihood of developing lung cancer. When determining the standard of care, the courts will also look to the likelihood and seriousness of the potential injury, the costs and practicality of the precautions, and the social value of the defendant's activities. Prowse v Stepney Borough Council 1951 illustrates that the court are likely to find the defendant subject to a higher standard of care if there is a risk of serious injury. I argue the severity of a rare form of lung cancer warrants such an increase. An employer is bound to provide a safe system of work as outlined in Wilson and Clyde Coal Limited v English 1938. The duty was further developed in Speed v Thomas Swift Company. The court takes into consideration the expense and proportionality of the expected precautions compared to the severity of the potential injury. Therefore, following Latimer v AEC Limited, the greater the risk of injury, the more the defendant has to do to eliminate the risk. I argue simple precautions such as wearing masks are not unreasonable, and the court will find your case to fall in line with previous decisions such as Pate v Cumbria County Council and Raham v Airy Rose Limited. The court will consider the social value of the undertaking. In Dayborn v Bath Tramways Motor Company Limited, Lord Justice Askew stated that the purpose to be served is sufficiently important justifies the assumption of abnormal risks. I argue that the purpose served by the Tate does not outweigh the risk of developing lung cancer. Turning to factual causation, the general rule established in Barnett v Chelsea in Kensington was the but-for test. The test is limited, and it would not be possible to effectively argue that, given that you will also work for the churches and have used the solvent in your own time. Fortunately, one only needs to prove that the defendant materially increased the risk of damage. Given the nature of Artium and the risk that it poses being similar to asbestos, the McGee test, as affirmed in Fairchild v Glenhaven Services, will most likely apply. This could face contention from the defence, given the Court of Appeal in Ellis v Environmental Agency refused to extend the Fairchild approach to ordinary industrial injuries. I'm confident this hurdle will be overcome due to the similarity of risk of exposure to Artium and asbestos. So, who would pay the damages? The House of Lords in Barker v Chorus Limited introduced the concept of proportionate liability. I consider the strength of the argument in proposing that the Court uses purposive statutory interpretation in relation to Section 3 of the Compensation Act, and deem that all liable defendants should, in this case, be jointly and severally liable. However, Section 3 of the Compensation Act only applies to mesothelioma cases, and the Court will be reluctant to open the floodgates and to claims of other industrial diseases, as well as arguably undermining the sovereignty of Parliament. I was supported by my assertion by Zurich Insurance v International Energy Group 2015. I now turn to causation in law. The test outlined in the Wagamount is that the harm must be reasonably foreseeable by the defendant. Given the medical understanding of exposure to Artium, it will be reasonably foreseeable that exposure to the solvent over a 5-year period will increase the risk of you developing lung cancer. Given the assertions made previously, I argue this point is beyond doubt. When establishing liability, it must be established whether there was a novus actus interveniens which breaks the chain of causation. Firstly, the defence will argue that the misdiagnosis of Mr. Khan was an intervening act, which I will consider later. Secondly, they will argue that the exposure to Artium in your own time is enough to break the chain of causation. For an act of the claimant to be an intervening act, it must be unreasonable in all circumstances, per Core v IBC Vehicles 2009, which this is clearly not the case. Furthermore, they'll try to argue that you're aware of the risk and gave your free consent. The defence will not succeed if you're able to prove that you had no choice but to accept the risk. Now, in employment terms, acknowledgement of risks does not warrant consent and acceptance, per Smith v Charles Barker and Sons Limited. I therefore conclude that the Tate Gallery is liable. Although the use of Artium in your spare time does not warrant an NIA, it is considered contributory negligence, which is a partial defence outlined in the Law Reform Contributory Negligence Act 1945 Section 1.1. The burden switches to the defence to prove, on the balance of probabilities, you have failed to take due care in the circumstances for your own safety. Jackson v. Murray outlines that the damages are apportioned and reduced by the principle of causative potency. Considering your experience, I suggest the court will apportion some liability at your feet, and your damages will be reduced by roughly 20%, as per Barker v. Chorus UK. Turning to your time volunteering at the church, I advise that you bring your claim against the relevant diocese rather than the individual churches themselves. Your claim will have a greater chance of success, as the court will be more comfortable levying damages against the diocese rather than individual churches, especially if they're small in size and in congregation. Lord Macmillan, in the aforementioned Wilson's case, stated the owner, in this case a diocese, is responsible for the negligence of a person whom he has appointed to perform his obligations, the churches, for him, and cannot escape merely by proving that he has appointed a competent agent. Ordinarily, volunteers are not afforded the same rights as employees. However, despite your volunteer status, the churches are still liable in claims of negligence for personal injury. And under both Common Law and Health and Safety Work Act 1974, Section 3.1, volunteers are afforded the same level of protection as employees. I assert the church owes you a duty of care, breach of duty, and there was factual and legal cause of developing lung cancer as a result of exposure. The claim is supported following my consultation with Ecclesiastical Group, who are a prominent employees' liability insurer for the Church of England. They have confirmed that churches should undertake risk assessments for all proposed volunteer work. Risk assessments must be provided to the insurers for their policies, and therefore they will evidence whether appropriate precautions were taken. If they're silent on the matter, which I surmise they will be, then they'll still leave the diocese open to strong claims. Once more, they'll be liable for proportionate damages in consideration of the time that you spent volunteering for them. Finally, I'll consider whether Mr. Khan's diagnosis warrants a claim of negligence for personal injury. The doctor-patient duty of care is well established. I was confirmed in Boland v. Frine Hospital. The case also confirmed that the standard of care for doctors is the standard of an ordinary skilled man exercising and professing to have that special skill. Given Mr. Khan's breathing specialist, he is required to reach the standard of a person reasonably competent in that skill per Wells v. Cooper 1958. However, the Boland test has come into criticism. Despite Davies argued that medical negligence has become Bowlemised, meaning in complex medical cases the courts have been reluctant to make their own judgment, rather they've developed too much on medical opinion. The House of Lords clarified the situation in Beliver in 1998, where it stated that although there was a recognised body of medical opinion in accordance with the doctor's practice, the doctor could still be held to be negligent. The court can decide that a body of opinion is not reasonable or responsible if it can be demonstrated that the professional opinion is not capable of withstanding logical analysis. This will be the matter of fact for the court, and the success of your claim will depend on the expert evidence given and the documented process of diagnosis that Mr. Khan undertook. Clearly, Mr. Khan's diagnosis is not the factual cause of your cancer. It is not possible to establish that but for Mr. Khan's actions that you wouldn't have developed the cancer. However, in such circumstances it is possible to argue the defendant's breach has lowered your chances of a more desirable outcome. This matter is contentious and turns on the chance of you surviving had Mr. Khan correctly diagnosed you. Greg v. Scott are found in Hodson v. East Berkshire by split decision 3-2. These cases are more important because they outline the claimant must have had, on the balance of probabilities, more than a 50% chance of survival. Given your state is between 45% and 55%, this is problematic. I personally share the opinion of Lord Nichols, who in his dissenting judgment claimed that it was irrational and indefensible for a patient to recover damages with initial prospects of 55% but then not 45%. Despite my personal beliefs, we must take the precedent established, and the claim should be focused on proving that you had more than 50% chance of survival. If it is deemed to be less, then we argue a change in the law is necessary, which may be possible given the House of Lords' position in 2005. With regards to legal causation and reasonable foreseeability, I am comfortable that you can prove that it is reasonably foreseeable that a breathing specialist who should be aware that you were exposed to artrim would have recognised the risk of lung cancer. Finally, the defence for both the Tate and the diocese will argue that Mr. Khan's actions broke the chain of causation, which in turn relieves both parties of liability. However, despite Mr. Khan's actions, the original defendant should be liable given the intervening act did not cause the loss per Knightley v. Jones 1982. Furthermore, given the rarity of the type of lung cancer and the limited knowledge we have of artrim, it is reasonably foreseeable that a misdiagnosis could occur, and therefore original defendants remain liable per Lamb v. Camden Borough Council 1981. On reflection, there are strong claims against each defendant. I consider the claim against the Tate Gallery to be the strongest, followed by the claim against the diocese and the claim against Mr. Khan. I am of the opinion that proportionate damages will be awarded with a reduction of 20% as a result of your own exposure in your spare time. Thank you.